salute you all. Thanks for always being online. Thanks for watching. Today we are under land law 1. And basically today's topic, all the major emphasis that we are on, we are looking at the conversion of a customary land tenure system into a freehold land tenure system. We are changing customary into a freehold. We are looking at the procedures. We are looking at what is needed and what is necessary for a customary land tenure system to be converted into a freehold land tenure system. So basically, what you have to bear in mind is that the authority comes in the grand norm, which is the Constitution. We shall look at Article 237, Clause 4B of the Constitution. Mandates or give powers for anyone that is in hold or that is in possession of a certificate of what? Certificate of customary land tenure system to convert his interest or his land into freehold, following the law that can be enacted by what? By Parliament. And the law that we know, it is the Land Act and the RTA, the Registration of Titles what? Titles Act. So put that in mind. And basically, here we are looking at the procedures. And one of the procedures, it is through application. You apply. And we are going to look at step by step. We are looking at conversion of customary land tenure system into a freehold land tenure system. And first of all, we shall start with the application. The applicant must apply to the area land committee. This area land committee is the one that receives the application. It's like, how can I say, it's the mediator within the applicant, is the mediator between the applicant and the district land board. You get, so put that in mind. So the applicant applies to the area land committee. This is provided under section 9, clause 3 of the Land Act, and also section 10 of the Land Registry Regulations what? Act. So put that in mind. These are the authorities that mandate. It is made through what? Through application. It is made to the area land committee, and it's provided under section 10 of the Land Registration Regulation Act and section 9 subsection 3 of the Land Act. So this application is taken to the area land committee. So basically here what you have to bear in mind, or what you have to put in mind, this area land committee has powers, and these powers are invested into, when you read section 5 subsection 1 of the Land Act and section 11 subsection 1 of still of the Land Act. It gives powers whereby the land committee has the genesis to determine, to mark and verify borders on that what? On that land. They go on the land, they determine, they mark and also verify the boundaries on the land that you want to transfer. You get, they determine, they mark and they verify what? Boundaries. So put that in mind. Following section 5 and section 11 of the Land Act. And also here, basically, through the verification, they also must verify the receipt, or the receipt of the customary what? Or the receipt of the customary certificate. You get? So bear that in mind. You must go with the customary what? Certificate to show that you are the one that is owning that particular piece of land under customary one, land, under customary land or customary what? Customary laws. So put that in mind. So after this area land committee making these recommendations or making these what? Investigations on the land, they make a report. This report is the one that is sent to the district land board. When you read section 6 of the Land Act, section 6, subsection C probably, of the Land Act, the area land committee sends a report, makes a report, which is sent to the what? To the district land board. You understand? But before even making a report, they have to put a notice. A notice is issued on land. What is the importance of this notice that is issued? The importance of the notice that is issued to make sure that anyone that is having a query, anyone that is having an interest on the land, so that he or she may come up and make what? Ask for remedy or make an argument or to fight against the conversion. You understand? So this notice is put on a clear, where it can be clearly seen on the piece of land. So anyone that is arguing towards the same should go to the area land committee to make his arguments or his query on the same, so as conversion cannot take place. But if there is no query after this notice is issued for a period of around, is it 2 weeks probably, after this notice is issued, so the area land committee makes a report, you understand, and this report is taken to the district land board. This district land board actually here, for him, his onus is to approve. Actually, before even approving, he first surveys the land. They make a survey on land, and it is under section 9, subsection 4 of the Land Act. They make a survey. After making a survey actually the reason as why they make a survey, to ensure that the recommendations, all the things, all the conditions, all the things that are provided in the report are in conformity with the what? With the report. So they go to ground, they make the survey on the land. After making the survey, they have to approve. You get? They approve. They approve the what? The report and the application. You get it? So on approval, after approving for them, this district land board, its onus is to send to the registrar, who is the commissioner, land registration. They send that report and a copy of the application. They send a report and a copy of the what? Application to the registrar, who is the commissioner, land registration, so that requesting him to issue a certificate of freehold, which is actually the copy is sent, or a copy is sent requesting. It is provided under section 13, subsection 1 of the Land Act. So they send this copy to the what? To the registrar, requesting him or her to issue a certificate of what? Of freehold. So basically here afterwards, the registrar has to look through, but all things are already done. So there is no always need of what? Need of making surveys among others. They follow the report and they consider the request. You get? They consider the request of the what? Of the district land board. So the registrar issues a certificate of freehold following section 14 of the Land Act. The certificate of freehold is issued in accordance with section 39 of the RTA, which is registration of titles what? Titles Act. Now the registrar puts on the certificate, puts these ones limited to parcels. You get? What do they mean? That it is like the area, they are only guaranteeing the area that is distinct or that is provided within the what? The title that is presented to the registrar. Any area that is outside is not guaranteed. That's why you put limited to parcels on the certificate issued, which is the freehold what? Certificate of freehold following section 14. So this certificate is taken to the district land board. It's taken back to the district land board. You get? So the onus of the district land board is to approve that, you know what? The conversion has taken place. It has turned from a customary to a freehold. So they approve. You get? So put that in mind. After approval, the applicant then enjoys the rights of a freehold, or his land is changed into a freehold land tenure system. So basically, that is the process. All those are some of the criteria or the procedures that are taken as per to ensure that land can be converted into what? A freehold. Thank you for watching. I wish you the best.